to be vetted. So there's a bit of inconsistency there. But all the same, is it last week actually, there are some new faces that will be attending cabinet meetings. And this is another matter that has been challenged in court. It was filed yesterday. That is of UDA Secretary General Cleophas Malala, Monica Juma, Advisor on National Security. There is Devin Day, Chairperson of the Economic Council of Advisors. And did I just say that right? And also there's Harriet Chigai, former colleague of President Theuri here, who is sitting there advising on women affairs. And when you look at this has been challenged. President Theuri is been challenged in court. There's also the question of the Finance Act that was also challenged last week. And there was some stay orders that the implementation of the Finance Act should not happen up until it's back in court, which is tomorrow. What does this mean for the Ruto presidency, and what does it also say in terms of the rule of law, but secondly, what advice the president could be getting at such a time?
It's very interesting. First of all, we know that one of the members of the Law Society has gone to court to challenge the so-called sitting of strangers in cabinet. I'm also aware that the Law Society ought to have filed, I think it ought to have filed it yesterday. If it wasn't filed yesterday, it will be filed today, challenging the same decision. There is already a ruling on this matter that was filed coincidentally by a sitting cabinet secretary, the Honorable Alice Wahome, who's also an advocate. And so this is one where we think that it's mischief that is not going to go so far. I think the right thing would be to comply with the formation of cabinet as set out in the Constitution, because an attempt to create an established government outside what is provided for in the Constitution runs foul of Article 3.2 and is likely to meet the same fate that the courts ruled previously. And so that's something that we'll be looking out for. But that said and done, there is, I'm aware that there was an application that was filed to set aside the orders that were given by the Honorable Judge Thande, suspending the implementation of the Finance Act. My suspicion is that the decisions that were taken maybe by EPRA to implement immediately the increase to 16% may have been pegged on the hope that the High Court may overturn that decision, which I think is a wrong way to approach court orders. And this is what Honorable Senator, who is also one of our members, said, that the Kenya Kwanza administration is an administration that has pledged to support the rule of law and abide by court orders. So I urge them to comply. The implementation of the Finance Act has been suspended. The right and proper thing to do is to comply with that decision and then challenge it if you feel that the decision has been made wrongly. So therefore, how do you then approach the court for a relief? You're telling it, set aside these orders, yet you're not complying with the court. Are you suggesting to the court that it is only decisions which are in our favor that we are going to agree with? So any person making that suggestion to the court then would find that the court would not be happy to entertain them. And so I hope that today, if not yesterday, a revision of the fuel prices will be done in line with the decision that has been made by the court, and a process of compensating those who have paid more than they ought to have paid to be conducted, so that we restore parties to enjoy the decision of the court. Otherwise, it would be going back to those days when court orders were treated as mere suggestions, and that is not a scenario that is good for the country.
Is there a possibility that you can compensate Kenyans who've paid for fuel 195 shillings per litre of petrol in Nairobi? Is it